The documents concerning the election in relation to the Governor-General have just been released, and these demonstrate how our Constitution works. It is an illustration of the proposition that the Crown is important not so much for the power it wields, but the power it denies others. So it's not for the government or the Prime Minister to call an election. This is for the Governor-General. This is done under Section 61 of the Constitution, which says that the executive power of the Commonwealth is vested in the Queen and is exercisable by the Governor-General as the Queen's representative, and extends to the execution and maintenance of the Constitution and the laws of the Commonwealth. Although the Governor-General is normally chosen by the Prime Minister and recommended to the Queen, he or she owes his or her loyalty to the Queen of Australia and therefore the people, and not to the politician who recommended him or her. That's very important. In 1907, 6 years after the formation of the Commonwealth, the High Court had to consider the role and function of the Governor-General. And it described the Governor-General as the constitutional head of the Commonwealth. The constitutional head of the Commonwealth. That's a description. It's not an office. It's worth looking at this correspondence. It's correspondence between the Prime Minister advising the Governor-General. And you'll see that there are notes by hand on the letter which have been done by the Governor-General. The Prime Minister went to see the Governor-General. He came with this letter and other documents. And he writes, I write to advise you to prorogue the Parliament, that is, discontinue meetings of the Parliament, and dissolve the House, as set out in the Constitution, and take the necessary action for a half-Senate election. He points out, in the second paragraph, that the current term of the House expires at midnight on Thursday, the 29th of August, 2019. He also points out that Section 28 of the Constitution gives the Governor-General a discretion to dissolve the House before that date. An election has to be held by the 2nd of November. Normally, the Prime Minister will advise the Governor-General, and that advice will be accepted, unless it's too early and the Governor-General feels that the House should be allowed to continue, or unless there is some dispute within the House, there's a change of government, and it's a matter for the Governor-General to decide whether there should be an election or another person should be called. Now, a half-Senate election has to be held because the terms of half the senators expire on the 30th of June. And obviously, it's more convenient to hold the half-Senate election at the same time as the House election. And that's what the Prime Minister proposes. And he sets out a timetable for the issue of the writs, that is the writs for the election, and the close of the rolls. You'll notice there's a delay between the issuing of the writs when the election is announced, that is, the day the Prime Minister has gone to see the Governor-General, and the closing of the rolls. The Howard government passed legislation to have the rolls closed on the same day as the issue of the writs. The Howard government was concerned that a very large number of new enrolments onto the electoral rolls occurs in that period, and it's impossible to check them. In a major case, funded by GetUp, the High Court decided in 2010 that the Howard government was unconstitutional. The Howard government's legislation was unconstitutional. This is a very controversial decision. In any event, there always has to be now a week between the issuing of the writs and the closing of the rolls, where there is a large number of new enrolments onto the rolls, many of which say can be fraudulent. Then the nominations are closed. That's the nomination of people wishing to stand. The polling date is set out. The dates for that are set out in legislation. The Commonwealth Electoral Act of 1919. And then there's the date for the return of the writs. The final paragraph on that page refers to the fact that the writs for the Senate are not issued by the Governor-General, they're issued by the state governor. And it's for the Governor-General to ask the governors to do that. Normally, this happens automatically. But in 1975, when there were questions as to whether there should be a Senate election to solve the political disagreement of the day, a long-term Senate half election, it was indicated that some states would advise their governor not to issue the writs. If you go over the page, you'll see that the Prime Minister says that he is enclosing a proclamation, a draft proclamation for the Governor-General to consider and then sign, which would be to prorogue the government, prorogue the Parliament, and then call the election. There's a very important paragraph on page 2. It's the second paragraph. And that's the assurance by the Prime Minister that there are sufficient funds available to enable administration and ordinary services of the government during the election period and until the new House sits again. It's very important that the Prime Minister be able to confirm that supply has been assured, that supply to the government is available so that the government can continue. This was very much an issue in 1975 when the Senate delayed the grant of supply to the Whitlam government until the Whitlam government resigned and called an election. And then the Prime Minister invites a confirmation, which is noted on the letter. And we'll go now to the actual letter from the Governor-General to the Prime Minister, indicating his agreement with what the Prime Minister proposes. Remember that saying, the Crown is important, not so much for the power it wields, but the power it denies others. The Prime Minister cannot assume that he will get an election. And when Prime Ministers in the past have attempted an early election because they were in trouble in the House, the Governor-General has not necessarily granted the request for an election. He's entitled in those circumstances to call on somebody else to form a government. This is very important because this is a constitutional monarchy. It's a constitutional commonwealth in which there are checks and balances on power, and there's a very important power, often referred to as a reserve power, in the Governor-General. The reserved powers of the Governor-General relate to the appointment and removal of prime ministers and the granting of dissolutions of parliament. And these are areas where the Governor-General acts on his own discretion. He may be advised, but he has an absolute discretion to decide whether to accept that advice. So we come now to the letter from the Governor-General to the Prime Minister. We see now the letter from the Governor-General to the Prime Minister, in which by hand he has written the salutation, "Dear Prime Minister." He refers to what happened. He confirms his acceptance of the advice to hold an election on the 18th. He says that he will invite the state governors to take the necessary action for the holding of Senate elections, and he agrees to issue a proclamation proroguing the Parliament, that is, discontinuing sittings of the Parliament, and then dissolving the House of Representatives. Note that he does not dissolve the Senate. The Senate continues. Only half the Senate goes to an election. The other half continue. This was something the Founding Fathers took from the United States. They wanted a Senate which had a longer term view than the House, which would exercise the necessary constraints on action by the House of Representatives and act in the interests of the states. It's sometimes said the Senate is no longer a states' house. That is partially true, but the Senate is elected on the basis that all of the original states, the 6 states, there being no new states, the 6 states having the same number of representatives. So it is produced in a different way to the House of Representatives, partially at a different time, and therefore can exercise a restraining influence on rushed action by the House. Going on to the next paragraph of the Governor-General's letter, he notes the advice that there are sufficient funds to enable the work of the administration to continue and be carried through until the new House sits. And then he says he has no objection to the release of the documents to the public. And if we go over to the next document, which is on the right of the slide, we see that there is a proclamation. It is signed and sealed with the Great Seal of Australia by Peter Cosgrove, Governor-General, and the traditional form appears at the bottom by His Excellency's command, Scott Morrison, Prime Minister. The Prime Minister countersigns the proclamation. And in the proclamation we see that I, General the Honourable Sir Peter Cosgrove, AK, MC, retired, Governor-General of the Commonwealth of Australia, acting under Section 5 of the Constitution, prorogue the Parliament. That's the dates of the times that the Parliament is no longer to sit, and dissolves the House of Representatives. Note again that the Governor-General does not dissolve the Senate, which continues, half the Senate going to the election, but the other half continuing. These documents are an important illustration of the role and function of the Crown in Australia and the way in which we have checks and balances which are so important under the rule of law, and the way in which our old democracy works. All of this is under one of the world's oldest and most successful constitutions, and it is something which we should all respect and indeed, I would say, treasure.